if I leave home, well, I tell she a real close. Girl, I almost did. All inclusive fete. Yeah, tonight go her real vibes. This crowd here go be real nice. Can't find me ticket. I done by the door. Realize I have to pay more. Find me ticket. I done by the door. Realize I have to pay more. I have to get in because this is not missing me. It's not missing me. I want to go big people party, make the music take over me. I want to jump up all day, all night. I want to wind up all day, all night. I want big people party, and liquor up inside me. I want to jump up all day, all night.
Before you this morning to offer you thanks and praise. Thank you, Lord, for sparing our lives that we may come together this morning to discuss our affairs and the affairs of Trinidad and Tobago. This morning, Master, we ask you to watch over our proceedings. Help us to deliberate and be respectful to each other. Help us abide in spirit and in truth and to do the things that are lawful and right in your sight. This morning, Master, we ask your guidance, your protection. We ask you, Lord, to bind us with a cord of unity that we may go forward with one head, one direction, one love until we achieve those things that we set out for. This morning we ask you, Lord, those who are still on the way, grant them traveling mercies that they may arrive safely and be part of these deliberations. Father and friend, we ask you to watch over us through the course of the day, and whatever decision we make, may you grant your success, and may you grant us that eternal victory that we so hope to achieve. This and all of the mercies we ask in your most holy name we pray. Amen.
In the trade union movement, he was a former executive member of the Banking, Insurance and General Workers Union, and up to recently he was the treasurer of the Movement for Social Justice. I'm talking about Comrade William Celestine, who suddenly passed away last week Sunday, and his funeral is actually this morning. So I really appreciate the Bigu comrades who, notwithstanding the fact that their fallen comrade is buried today, they still was able to send down a delegation. We really appreciate that, and in recognition of such, we like to have a 1 minute silence for Comrade William Celestine. Okay, thank you. I'd like for us to now sing the May he rest in peace. Amen. I'd like for us to now sing the national anthem. All right, we will remain standing for a little while longer because we are, of course, at the headquarters of the Oilfield Workers Trade Union Paramount Building, and we do not start any event in this hall without, of course, our own union anthems, which are the union songs. So we need to start this National Conference of Shop Stewards and Branch Officer with some vibes. And to do that, I know many of you all are accustomed to the President General being the choir master, but he has a young protege, another choir master. I call that succession planning. We have, of course, Comrade Aaron Moyne, who would lead us into union, a very, very vibrant series of union songs. Comrade Moyne.
I can borrow your voice? All right, here what I like. When we're singing, let's sing every word. We want to mean every word because I know that some of us took day offs, some of us took time off to be here. Anybody here was forced? Nobody was forced to come with the threat. I was listening to the radio this morning and how many people may not have a job this morning because they didn't attend a particular place yesterday. We don't have that problem because we are union, we are free, we are united, we know what we mean. And we're really glad to have everybody here. So as we sing these songs, we meet today in freedom's cause. Even if you don't have a voice, say it like a poem, right? But we want everybody's voice to open up, right? We ready? You ready? Tell your neighbor, say you ready? Right. We meet today in freedom's cause and raise our voices high. We join our hands in union strong to battle or to die. Hold the fort, for we are coming. Union is be strong. Side by side, we battle onwards. Victory will fierce and long, the battle rages, but we will not fear. Help will come when help is needed. Cheer my comrades, cheer. Hold the fort, for we are coming. Union is be strong. Side by side, we battle onwards. Victory, we meet today. We meet today. Let me hear your voices. Go ahead. We join with our hands in union, so to battle. I want you to hold the fort, for we are coming. Union is be strong. Side by side, we battle onwards. Victory will, we shall overcome. Sing, we shall overcome. Hey, we shall hey, we shall overcome. Some, for deep in my heart, deep in my, I know that I do be. We shall overcome. Let me hear you sing, we shall overcome. Let me hear you sing it louder. We shall overcome someday. For deep, I know that, we we shall overcome. Someday, any day now, we shall overcome. We shall overcome, we shall overcome someday. For deep, I know that I do believe we shall overcome some. When those who labor, hold the reins of power. Hey, when those who labor, hold the reins of power. Oh, I would like to be in that number. When those who labor, hold the... Let me hear this side alone. Let me hear your voice. When those who labor, just the side. Let me hear you. When those who labor, hold the reins. You gotta sing it like you believe it there. I would like to be in that number. Let me hear you sing. When those who labor, hey. Let me hear this side. When those who labor, hold the reins of power. Hey, when, hey. Solidarity forever. Our union makes us. Our union makes us strong. Power to the workers. Power. Ozzy.
I know after that session they don't want to sit down, but we can have our seats now. Let us give Comrade Aaron Moines a really big round of applause for waking up. This is very important. National CASSABO. We're right now trying to make some arrangements to get some more chairs down so that the comrades from Postal can be accommodated. We have some more chairs coming down. Comrades, good morning. Comrades, good Monday morning. This is a beautiful Monday morning. When the JTUM took the decision to hold a national CASSABO on this thing we're going to discuss today, and we went out to do our various internal mobilization, the fact that so many branch officers and shop stewards came out this morning says that we are serious about workers' business. And I am sure, unlike other places, everyone in this hall know exactly why they're here this morning, correct? I believe when we registered, all delegates would have gotten a copy of the bill. I want to make sure that that is correct. Is that correct? Everyone in this hall have a copy of this bill. All right. What we want to do is to recognize all of the various units who have overwhelmingly responded to this important, critical, historic National Conference of Shop Stewards and Branch Officers. I want to first recognize, coming out in a large number, first earlier this morning I was getting worried, Khaki Shirt Brigade, good morning. Let's give them a round of applause. Communication Workers Union. Coming out in their numbers as well. Steel, coming to give some steel this morning. The Steel Workers Union. Good morning, Steel Workers. Wait, I didn't hear Steel Workers. Good morning, Steel Workers. All right, singing good. Coming out in a large with a large contingent. The Transport, Industrial and Workers Union, TWU, here with us. Good morning, TWU. coming out in their, I know they probably want to change the color, but they came out proud this morning. They come out representing a proper yellow, union yellow. That is Contractors and General Workers Union. Let's give them, contractors, good morning. Coming in with a very huge contingent. So comrades, please do not look forward to get your post anytime soon, because it seems that all the postal workers here this morning coming in with a huge contingent. Bringing in the rear there, we have Postal Workers Union. Postal workers, good morning. With flag and all. In front here, making sure that they always come out. They came out this morning, and as I said earlier, notwithstanding this morning being the funeral of one of their ex-executive officers, they still send out a nice contingent to discuss this very important IRA amendment bill. I'm talking about the Banking, Insurance and General Workers Union. But Bigo, good morning. We have even the teachers here with us this morning. I want to recognize the Trinidad and Tobago Unified Teachers Association. Tutor, good morning. Joining us is, of course, workers from the Amalgamated Workers Union. Amalgamated Workers Union, good morning. I saw a comrade earlier, and I want to recognize, of course, locked in some bitter battles. We're talking about the Prison Officers Association. Let us recognize Prison Officers Association. Good morning. I see him way down in the back, a lone figure. A big union, but he's here by himself this morning, unless he have one or two other comrades with him. But I do want to recognize a member of the PSA Rebels. Good morning, PSA Rebel. I don't know if I leave out anybody. I left out anybody? And of course, we are at the home of the Blue Shirt Army, the Oilfield Workers Trade Union. OWTU, good morning. To all delegates representing all these unions who came out this morning, one more time, good morning. Are we ready to discuss the business of workers? Are we ready to discuss this anti-union, anti-worker bill? You all not sure? I'm talking about a different bill or what? I'm talking about the same bill? As far as I know, I'm talking about the Industrial Relations Amendment Bill 2015. Are we ready to discuss this? Yes. To chair this national CASSABO, I would like all of you all to join me in welcoming a champion in the interest of workers and the people of Trinidad and Tobago. And I have no fear in saying that. Workers and the people of Trinidad and Tobago. And I'm talking about the leader of the Joint Trade Union Movement, the President General of the Oilfield Workers Trade Union, to officially open this national CASSABO. Join me in bringing on Comrade Ancel Roget.
Comrade Ancel Roget, our Chief Education and Research Officer. Comrades, good morning. Let me recognize all our comrades, our colleagues at the head table, members, all members of the Joint Trade Union Movement of Trinidad and Tobago, a body that encompasses all the trade unions, regardless of the umbrella body that from which they emanate. We embrace all trade unions, and that is why we are with the name Joint Trade Union Movement. I want to, first of all, comrades, I want to take us back a bit before we get into these discussions here this morning. it is very important that we put into context where we are and why we are here. And so you would recall, comrades, on Sunday, April the 18th, 2010, some 18 trade unions, the same body, gathered, with the exception of 1 or 2 or 3 of them here this morning. I haven't heard their presence announced. But generally, some 18 trade unions representing workers across all industries and companies, state bodies and so on in this country came right here, and we formulated what was described then and still is described as the workers' agenda. Now, in the workers' agenda, quite apart from issues unrelated to or not directly related to workplace issues, issues of constitutional reform, issues of youth and farmers and agriculture, issues of governance, we had a significant number of specific recommendations we had agreed upon with respect to the Industrial Relations Act. Now, we must always remember, comrades, we must always keep in mind that regardless of who say what, whichever government is in power, at the end of the day, it is we, the workers, who turn the wheels of the economy. And therefore, most times, business community, business interests, government, they speak in abstract terms as if they take all of us for granted. And therefore, they take your union representation for granted. And therefore, it's a done deal as far as they are concerned. We took a proactive position. We said then that insofar as this anti-worker law is concerned, which employers and government, all of them, would have used against workers, we want to see significant amendment to this Industrial Relations Act, this anti-worker piece of legislation. And so since its inception and implementation, since passing of this bill, way back in 1972, we have had some changes to that act. But every time you have changes to the act, none of those changes would have facilitated or would have favored the workers. Indeed, it was made more difficult for workers to get justice under this piece of legislation. And that is why it was so important for us to put into that workers' agenda all of these necessary amendments. But lo and behold, those who then seek in office, and I did say, comrades, I want to put in context where we are and why we are here this morning. Those who were seeking office then embraced the workers' agenda, embraced all of the changes, committed to having fundamental changes to the Industrial Relations Act. And therefore we sent specific persons on a mission to oversee those changes. Fast forward the tape, and you would find 4 years and 11 months, 1 month before the expiration of their term in office, they rush a bill to the Parliament. Not only that they rush this bill to the Parliament, what the bill contains is what ought to concern deeply all of us, and I dare say every single worker in this country. So all the talk, we were talking all the time. We had year 1, year 2, year 3, year 4. And we were saying that you committed to doing this, to changing this law. Which law, because of you not changing it, you were able to use it against workers for 4 years, 11 months. 4 years, 11 months, it was non-settlement of negotiations. It was workers having to march against an imperialistic, unfair, unjust 5%. It was unions being taken to court. It was unions having won matters in the court. Those matters were constantly appealed, and in some cases, right up to the Privy Council, using their deep pockets. Attorneys having a field day in what we call an industrial relations gate. There are many gates these days. Industrial relations gate, where state sector paid their friends, exorbitant amount of monies to just file injunctions against workers, against their trade unions, and in some cases indicating that they want to decertify, and in the case of OWTU and NP, clearly indicating that they are going to decertify for the certification of the Alphys Workers Trade Union. Employers having a field day throughout this 4 years and 11 months. Employers using this anti-worker piece of legislation to beat workers into submission in cases where that occurred. But we didn't submit, comrades. And I want to say at this juncture this morning, I am very pleased to see the response to come and discuss our business, the future of workers and workers' interests in this country, the overwhelming support that we have here this morning. Very significant, because you sent, by your presence, you sent a message already. You have already sent a message to all alike, government and anti-workers, all the anti-workers, all the anti-unions, all those employers, that we are prepared to take the bull or the cow by its horn. While all of those things were happening, we were saying that the workers were betrayed. Indeed, we were deceived. But we were pressing, comrades, we were pressing forward in an election season, and we cannot discuss anything without discussing the background within which all of this thing is happening. We were saying that election coming and all who are vying for political office must show their hand. So the Joint Trade Union Movement decided that we want to hear from all of those who are trying to get into government to govern this country. What is your position on the workers' agenda? We didn't question or have any discussion with the UNC People's Partnership, whatever is left of that. We had absolutely no discussion, and for obvious reasons, because they had it within their mandate to implement, and they did not implement it. And therefore we ask the political parties, the PNM, the ILP, and of course MSJ, what is your position on the workers' agenda? What is your policy on labor issues? Because we believe that we have a responsibility, a duty to ensure that workers are guided along the best policy or policies that would favor us going forward. And so we had 2 rounds of meetings. But because of that, and because they failed to do what they were mandated to do, what they had committed to do, and they saw these discussions taking place, they rushed a bill which they had absolutely no intention to passing in the first place, but to say that they did something for labor on the very last moment, just before they departed, they brought this bill. So it was no favor, and I want us to understand, absolutely no favor to any worker in this country that this bill was laid in the parliament. And comrades, very strange, May the 1st, while we were marching in the streets of San Fernando right here, celebrating on the one hand the achievement of an 8-hour workday, and on the other hand pointing to all of the deficiencies that exist, all of the attacks, all of the rollback, all of the fight back to take away that particular achievement and all the other achievements that workers would have won throughout their years of struggle, while we were identifying the deceit of persons who had committed to put workers at the center of development, right here in San Fernando, that is the day, May 1st, May Day, they choose to lay this anti-worker, this most vicious piece of legislation in the parliament. And of course, I wish to make the point for yet another time that despite on May the 7th, when they started debate on this bill, despite the Minister of Small and Micro Enterprises, despite all of his pronouncement, you know, you listen to him and you would believe that he loved workers and that 4 years and 11 months would not have gone by, and that he was not the one who stood idly by and allowed workers to be dismissed, allow workers to be fired for political reasons. Once you look like a PNM, they fire you. Victimize workers on the basis of if you are prepared to stand up. Most corrupt government, corruption which pervaded all of the ministries, which at the end of the day impacted workers' issues. Calling of state of emergency against all of us here, the workers. Workers in this country, trade unions in this country, fighting against a 5% in 2011. You would have believed, listening to him, that he was with us when we were fighting against all of those injustices. But we know the truth. And so all the mama guy and so on that would have preceded his starting of the debate on May 7th, we took that for just what it is, a lot of old talk and a lot of deceit. But I wish to say for yet another time, comrades, that we had absolutely no discussion, no consultation on this very important bill, a bill that would change the lives of working people, trade unions, for even as bad as it is, even worse. Absolutely no consultation. And I heard the pronouncement of coming out of the National Trade Union Center that there was also no consultation. Coming from the Federation of Independent Trade Unions and NGO, clearly, absolutely no consultation. That is the level of disrespect they have for workers in this country. Workers who pay their salaries. Workers who provide the revenue for them to corruptly steal. And so, when he laid this piece of this bill in the parliament, he spoke in glowing terms, as if this was the answer to all of the problems that we experience. And in particular, he mentioned a couple things. One of which was that since coming into office, he as Minister of Labor would have withdrawn from the court matters of this certification. And that is where you had the Transport and Industrial Workers Union and the Communication Workers Union facing the certification in 2009. Come to remember, all of us had to come together to make one statement, which was that we were not prepared to see any trade union decertified at all. And they had to back off then. But even more than that, that issue was dead in the water with the employers withdrawing that application for the certification. But in true UNC style, he came to the parliament claiming that he would have withdrawn that. But even more than that, that they are removing the provision in law in the Industrial Relations Act that would allow for any employer to decertify any union. In other words, in his words, they are leveling the playing field. And then you had coming after him one Rudy Indar Singh. Now, both of them were here on April the 18th in 2010. Rudy Indar Singh, minister in the Ministry of Finance, talking about extensive consultation and so on. Because he was responding to a letter read into the Hansard by the member for Chaconas West. And that letter was penned by the president of FITON, Federation of Independent Trade Unions and NGOs, Comrade Joe Remy here, responding to the fact that there was absolutely no consultation, but pointing out some major concerns and deficiencies within the same bill. But that Rudy Indar Singh and MacLeod would have been talking about this extensive consultation that they had and so on. And I want to again, comrades, for the benefit of the country, for them to know that we had absolutely no discussion or consultation on this very important bill. In fact, it was said by a number of their mouthpieces, including Indar Singh, the minister in the Ministry of Finance, that the Industrial Relations Advisory Committee had a member of the trade union movement contributing to those discussions which led to the formation of the bill. While that is true, what did not happen is that having drafted a bill on the basis of consultation, that bill was never sent to the trade union movement for its perusal and its scrutiny, and for it to make contribution, any type of contribution or amendments. But what is common here in this approach, we liken it to Section 34 and the runoff bill. That even though you would have had someone as a member of that Industrial Relations Advisory Committee, nowhere in those recommendations, and we have a copy of the recommendations, nowhere in those recommendations anything was mentioned about specific parts of this bill. And one part in particular, I tie it back now to the provision in the Act that allows the employer to go to the court and ask for our requests that a trade union be decertified. So while Minister of Labor was saying they level the playing field, what he did not say in his presentation, what the committee did not recommend, is this part 5A, which now makes it more easier for the employers to have a trade union decertified. In other words, this amendment favors even more the employer. And they can say what about this bill? Two things. One, no consultation, and two, that if you have a law, which law is now made much easier to decertify a trade union, well then that's the death of the movement. That you cannot have a provision that says, in the first instance, that a worker who is not a member of a trade union already receiving the benefit of collective bargaining, such a worker now must have representation by a trade union, even though he or she is not a member of a trade union. And you call that a benefit to workers or to members or of trade unions? That is the beginning of the end. That you already have workers who are chained up for one reason or another, who either you dislike Roget because he against your government, or you dislike him, he against every government, or you dislike leaders of the joint trade union movement. You find what they're saying, it don't favor your government. You find they're talking about corruption too much. You find that they're calling out your minister's name. You find they want to get the police to jail chairman of board of directors and president of companies and so on. You just don't like the union. You're just plain for whatever reason you're anti-union. Such a worker, not paying dues, must get representation. And if he or she believes that that representation is not adequate, he or she could take the union, petition the court to have the union decertified. Now what madness is that? So then what you are saying to our members, which members, some of them may not even like the union, but they have to join the union because they recognize that they want to be a part of the collective, they would now say, well, best I leave the union because I get in what is when they negotiate, I will get that. When I will get representation too, I don't have to pay dues, so I better leave the union. It's best this union really are doing anything for me. And Errol McLeod, Rudy Endau Singh, Kamla Persad-Bissessar, because she's a very integral part of all of that, would tell workers in this country that this bill favors workers. You could have whatever provision contained in this, if you're lucky to find it favoring workers. But if you're not representing those workers as a recognized majority union, that is of no benefit to you. So the employer tells the worker, you want to get a promotion tomorrow? Hear what to do. Go, let them represent you. That matter, they will get through that matter. Let them represent you. And you will file a case, you will petition the court for inadequate representation or so. And you have Lennox Marcel, washed up, put away, and should have done in place in industrial relations cemetery, Giuseppe, and all of those hired guns, paid by the government, eat a food, contracted to, train their guns on trade unions, selling this piece of anti-worker law that, if allowed, would see the death of the trade union movement in this country. We cannot, comrades, cannot, shall not, dare not, will not allow for this bill to become law. And by letter dated May the 13th, the joint trade union movement would have written to the Minister of Labor requesting, on the basis of a number of concerns raised in the letter, we raised some 8 concerns for clarification. And we said to him that if we are to make any meaningful contribution to this bill, because we were not consulted, we need clarification, and of course, we need time. And in the meantime, withdraw this bill. To date, we have not had a response. We have had absolutely no response to our concerns. Trade union movement telling you that they had no consultation. Across the country, you're hearing that there was no consultation. But you're still going ahead with this bill. Just to say, comrades, just to tell the country that they kept their commitment. But in doing that, drafting and bringing into law the most dangerous amendment to this bill since its formulation in 1972, these amendments in 2015. Well, we decided in true trade union style, in the tradition of the movement, that the answer lies not just with us, but the answer lies with all of the workers in the country. And therefore, to be able to articulate, to be able to, first of all, engage the rank and file and have them seized with all of the information, pros and cons, benefits and fallout, what we are talking about, the dangers in this bill, we decided on today's activity. And it is hoped, comrade, that at the end of these discussions this morning, because we are going to have a very focused discussion, we are going to have a presentation by Comrade Burke, who was a member of a committee set up by the JTUM to look at the bill and to pull out of this bill areas of concern and so on, and of course to make recommendations. We are going to have a presentation, and after that presentation we are going to open the floor for comments and for suggestions and for feedback and for all of the above, so that we can formulate a position, a concrete position on the way forward. We cannot expect anybody else to discuss our business. We cannot leave it up to no government, or we cannot leave it up to no business or employers. We have to determine where we go from here. And I want to say to comrades that whatever position that we take here today must be owned by all of us, meaning that we must be prepared, well prepared, to implement whatever decision to the very last worker, having the very last worker understand. Because if he or she, those workers whom we represent, our members, if they are to depend on John Public or government spokesmen and spokeswomen on this issue, we would have failed in our duty. We have a duty and responsibility to properly and thoroughly represent them. And the decisions that we take here this morning must be carried through to every single worker at every single establishment to reinforce that position. And I'm not now going to preempt because I don't know what the decision might be, except to say, comrades, that all of us must be prepared to do whatever becomes necessary to ensure that we have a better Trinidad and Tobago. And you know, a better Trinidad and Tobago cannot be without better workers being treated with decency and dignity and with a level of respect that we deserve. We as the Joint Trade Union Movement, regardless of who, want to sell their souls on the altar of political expediency, or who want to eat a food, we are saying this morning, first of all, on the basis of our gathering here, that we reject outright this bill, and secondly, we are now going to formulate a position that we demand that the government take into account. And so, comrades, this morning I have great pleasure in welcoming you here and opening what will be a very historic discussion, which will go down in the annals of history, the intervention that was made by the trade union movement in our history. Thank you very much and welcome. Okay, comrades, I have been given the responsibility to chair this meeting here this morning. So we go straight into the presentation, and may I invite Comrade Peter Burke, Executive Vice President of the OWTU, to make this presentation here this morning. Comrade Burke, let's welcome Comrade Burke.
Distinguished heads of sister trade unions, comrades all, good morning. It is with distinct pleasure that the JTUM addresses this massive turnout of shop stewards and branch officers this morning to address a very important issue that would impact not only on the workers, but on the whole concept of trade unions themselves. In doing the research for this presentation, it became very clear that this is a carrot and stick piece of legislation. There are certain things in there that would seem on the surface to be welcome, but there are certain things in there which, as the chairman of the JTUM referred to just now, these things are going to threaten the very existence of trade unions. The context of this bill has to be examined, because almost more than just about 5 years ago, comrades gathered in this said room, more than 300, to put together a package of what you may call policies to follow and to seek the interests of workers. At the end of the day, 19 trade unions signed on to this package of policies, which became known as the Workers' Agenda. And it really dealt with issues which impact not only on labor legislation, but it impacted on environment, social justice, and having a sustainable economy so that workers will have a higher standard of living. This policy, the Workers' Agenda, was adopted by the newly elected government as government policy. But as comrades are well aware, none of these policies have been put into operation, despite several calls from the leadership of the JTUM and civil society. Comrade has alluded to the fact that 35 months into their term, nothing was done. And the key part of the labor legislation package, which the JTUM has identified as needing reform, only after 35 months was there any attempt to bring a legislation into Parliament, and it was done in a most surreptitious manner. For commoners to understand how serious it is, one has to look at the process of bringing a bill to Parliament. First, there has to be the concept of the bill. That concept will have been aided considerably by our COSSABO 5 years ago, where at least 9 or 10 fundamental issues was identified for the Industrial Relations Act and adopted by government policy. So you have the concept for the bill, then you generate a white paper, and it comes out of consultation. After that consultation, you generate a green paper, more consultation, and then a bill is drafted. When that bill is drafted, fundamental consultation must take place before it is introduced into the Parliament for debate. When it goes in the Parliament for debate, normally, depending on the seriousness of the bill, especially one requiring constitutional majority, you would have a situation where a joint select Parliament or the Parliament goes into committee for discussions on that bill. No, none of these things were done. So it was a rushed piece of legislation, and it was put in there in a very strange context, the context of an impending general election, and a context which precluded any serious consultation with key stakeholders. Now, the key aspect of this discussions will be identified by examining the provisions of the bill, which is called the IRA Amendment Bill 2015. Now, before we go into the actual provisions of the amendment bill, just for the sake of comrades getting a further context for which this bill has been placed, we examine the workers' agenda and what were the main issues identified for improvements in the IRA. The first one, the current bill, the current act, really has severe limitations on the right to strike, and that impacts very, very negatively on workers who work in industries considered essential service industries. Statistically, you have seen in the last 20 years or so, we have had 1 or 2 strikes. The last one being the heroic struggle by the TCL workers who eventually prevailed. And let's remember that by giving them a round of applause. The second item identified by the agenda has to do with the repealing of provisions which allow unions to be decertified. Now, we've had in the last regime, the PLM administration before this one, attempts to decertify at least 2 unions. I believe the CW and TU. And the movement coalesced around these comrades, and we prevailed. But the fact is that there's a serious problem where in the Act there's legislation provisions which will facilitate the certification. And we thought that it needs to be changed. And we are hoping that any serious government who has the workers' interests at heart will make it, will repeal those provisions. The third is to facilitate the unfettered right of workers to join a trade union of their choice. Comrades would know the difficulty of getting certification and recognition for trade unions. I am aware this union has had an application for one company for 10 years, and after 10 years we were denied. We have situations where the companies take the opportunity because of the long delay in recognition and certification to reorganize their companies, and many times at the end of the process a lot of your members are either sent home or forced out or fired, and there's no protection for the workers in this context. We also wanted to ensure that the process of recognition and certification should take just 3 months, and it's important that we appreciate the speed on doing that, because anything else would frustrate the right of the worker to be part of a trade union of its choice, which is a constitutional right. One of the key aspects and one of the key deficiencies of the current bill is the fact that judges of the industrial court don't have security of tenure. They have a 3-year contract, and the Act does in fact provide for intervention by the minister and several issues. So they are always on some sort of tender on eggshells, because coming down to the end of the contract, one bad judgment could mean the difference of getting a new contract or getting sent home. And clearly, this is not the sort of environment that you would want to have judges dispense justice in a higher court, or any court for that matter. The workers' agenda also calls for an independent body to help select judges for the industrial court. Comrades will be aware that in the normal run of things, the Constitution provides for an independent committee called the Joint Services Legal Committee, which is chaired by the Chief Justice and is charged with one of the responsibilities charges of selecting judges for the High Court. Given the fact that the industrial court is a different type of court, which is not only judges of the court are not only coming from the legal profession, but various types of expertise coming out of industrial relations and so on can qualify to be a judge there. So therefore, a different type of committee, of institution is required to assist in selecting judges of the industrial court. So the workers' agenda call for the establishment of such a committee. The workers' agenda also calls for an all-encompassing definition for the worker under the Act. Now, public servants are not considered workers under the Act, and domestics are not considered workers under the Act. And because they are not considered workers under the Act, they are treated in a particular way. So the workers' agenda called for an all-encompassing definition of the word worker in the meaning of the Act. The workers' agenda also called for the Ministry of Labor to become more user-friendly. And whatever legislative remedy that could be employed, we feel that the Ministry of Labor needs some serious retooling in order to meet the needs of the workforce. Currently, the ills there include, sadly, a lot of contract labor. And not only the conciliators are on contract, you have institutions coming under the purview. The OSH agency is one. We have no end of problems engaging the OSH agency. Because of the poor terms and conditions, you find that these officers feel a pressure to do their jobs in a professional manner. Because A, they are under contract, no security of tenure, so doing their jobs in a fearless manner is reduced considerably. We also observe that in the legislative, we need legislative measures to prevent employers from frustrating workers from non-unionized environments to be represented by unions of their choice. Now, comrades are all well aware how difficult it is to go into a new environment, to recruit members, or how difficult it is for those members to seek representation and to encourage trade unions to apply for bargaining units in these companies. They are threatened, they are fired, and so on. And while in Latin America, it's probably worse, in Trinidad, they have their subtle and not so subtle methods to discourage workers from being, exercising their right to join a trade union of their choice. So that's the context in which the workers' agenda attempted to address with the shortcomings of the Industrial Relations Act. Comrade also alluded to the speed of this particular bill being conceived and fostered on the Parliament. But in the debate that precluded the IRA was rushed through in one afternoon as well. It seems that this is the way our politicians deal with workers. The bill was rushed through in one afternoon. The then government had a really large majority, probably the largest majority in the history of this country. They won all 36 seats in the 1971 elections, and they put it to work to pass this bill, which requires a special majority, and they rammed it through the Parliament in one afternoon. So that is not a new phenomenon at all. So come on, let's examine the bill itself. The bill is called the Industrial Relations Amendment Bill 2015. This bill also requires a special majority. The definition of worker, and you'll know in the front of any bill or any act of parliament, there'll be a section for definitions, and the committee paid some attention to the definitions contained in the bill. And we were not satisfied, comrade, that the worker definition was addressed, so that will encompass one definition for workers, and that all workers, in quote, unquote, all workers will be treated similarly. The definition of employer still excludes householders who employ 3 or less domestic workers. Now, the bill refers to domestic workers, and then is very specific with chauffeurs and groundsmen and so on. These are the categories. Despite what one expects the domestic worker to be, they identify these 2 other categories. But unless you have more than 3, you are not considered an employer in the meaning of the Act. The bill also changes reference to industrial court judges from members, and it proposes to start calling them, refer to them as justices. It also did not address the security of tenure demand adequately, which is a key issue if we are to be satisfied with any remedy to the IRA. For the reasons I just described and the chairman of the meeting described earlier. They have given them, they are proposing a 5-year contract, 5 years reminiscent of the term of a political party in government. Section 5 of the IRA, this amendment bill, proposes to repeal that. Section 5 has to do with terms and conditions for judges. And one of the issues, I am not too certain how they're going to deal with that. I didn't notice any new section that will address that. This bill proposes a limit of $75,000 as a fine for contempt of court. The court also, the bill also proposes a reorganization of the Recognition, Registration, Certification Board, which has been one of the biggest failings of the current infrastructure and the current legislation. I think one of the most frustrating aspects of having to deal with the court as a practitioner, they will tell you, is having to deal with the RRCB. But how it has been dealt with is an issue that we have to discuss this morning. The bill establishes qualifications for members of the board in a new section called 22A. Section 23 also establishes a quorum for the recognition board. It changes the quorum. And Section 32 deals with the recognition process, and we ask for a 3-month process, and the bill proposes a 6-month process. The bill also repeals Section 34(2) of the Act, right? And it provides for the prompt recognition of unions after objections have been found to be unfounded. Objections to recognition should be filed within 28 days of the application for certification or recognition, and it sets conditions for recognition on a relevant date and the application of more than 50% of members who are in good standing. The bill also proposes that the termination of recognition certification claims should be done in 6 months. I just alluded to an example where recognition took 10 years, the process took 10 years, and the union still did not get the recognition. So it is something that is a real sore point for trade unions, and it really gives the employer upper hand in preventing unionization of its employees. Now, comrades will understand this is a very serious problem, and it contributes significantly to the fact that trade union membership is now just about 20% of the workforce. The largest industry in terms of employees is the security industry, and because of the absolute dearth of representation by trade unions in that industry, these workers are the most exploited workers in employ in Trinidad and Tobago. So these recommendations coming from labor are critical in ensuring that there's social justice in the country. The bill also amends Section 40. It deals with failure to meet and treat. Now, currently, failure to meet and treat is an industrial relations offense, which is criminalized. Now, pay close attention to what I'm going to say now. Now, they have decriminalized the act, and several sections will be impacted by the decriminalization of the act. But what is very strange, failure to meet and treat, besides being a criminal act now, it draws a fine of $4,000. By decriminalizing it, the only liability to errant employer will be the $4,000 fine. And comrades can determine in their own mind what you think is going to happen now that has been decriminalized and the fine remains at $4,000. And clearly, that small fine really would ensure that there's an incentive now by errant employers not to meet and treat. The Act also amends Section 41, and that increases the powers of the chairman of the RLCB, right? And particularly in Sections 3A and 42D respectively. Now, these are it addresses in a very real sense one of the concerns about recognition for workers who are employed, let's say, in construction industry, right? And it grants powers to the chairman of the board, and that's something we need to, it emphasizes the chairman, right, to receive applications for processing of short-term certification, to determine the bargaining unit appropriateness, the certification of short-term projects, and the bill describes the effects of short-term certification, and the issues and contents of short-term certification, cancellation of the short-term certificate, and the treatment of short-term projects. Now, this is a significant amendment which will impact on those workers who have short-term employment, particularly in the construction sector. Right, the bill also amends Part 5 to replace the minister with a chief conciliator and establishes a new statutory body called CAMS. CAMS. And it stands for Conciliation Mediation Service. CAMS. CAMS, you know. The reference to the statutory body will replace the minister as conciliator. And while that might be a good idea in the short term, there may be long-term consequences to that, which the labor movement might have serious problems with. Now, the establishment of this conciliation and mediation service is covered in Section 24(5)(b). It replaces the conciliation unit of the Ministry of Labor. It will be run by a 14-member council. 8 members are appointed by the President based on recommendations from ministers and the Chief Secretary of the Tobago House of Assembly. Now, if you have 8 members being nominated, and which the President has no discretion, once they are nominated by these politicians, he has to appoint them. 2 from employers, and the male employing organization will nominate these 2. 2 from labor, and members are appointed for 5 years, and CAMS also is empowered to regulate its own business. Now, we have to look at the implications for the current employees of the Ministry of Labor and whether this development is really a good thing or a bad thing, because at the end of the day, it creates more infrastructure, and it would also increase the influence of politicians. Now, comrades, let's just look at that for a moment. I said 8 of the members would be appointed by ministers of government, nominated by, to be legally accurate. The Attorney General, the Minister of Labor has 3 nominations. You have Minister of Trade. You have the Chief Secretary of the Tobago House of Assembly. You have the Minister of Finance. So, is it really necessary for these ministers to have a say in something that is impactful on labor, where the 8 out of 14 of these members are nominated by politicians? Okay, so what is CAMS expected to do? Well, the bill proposes to improve the industrial relations and collective bargaining, to provide conciliation services, to advise all stakeholders in the IR environment, to inform stakeholders on IR-related matters through publications, to inquire from any industry about IR-related matters and publish its findings, to improve industrial relations practice in this jurisdiction. The bill also amends Section 51 of the Act to remove the requirement of a worker in good standing. And I think this is where the trade union movement has to be very vociferous, because they're starting to go down a very dangerous place. It repeals subsection 4, which grants the minister the right to grant extension to report matters. At the same time, it increases the time for reporting the disputes to 2 years. Now, it includes the inclusion of the employers of domestic workers with the condition that once it's over 3, they are considered employers. So that would be a very limited amount of householders. And the court is to determine if the aggrieved is a worker according to the Act. Now, this is important in the sense that the board is the one that does the deliberament. And as I alluded to before, the board is one of the most difficult creatures of the court to deal with. And it takes a very long period of time. In the last year, there wasn't a board in place, and all matters under the board's purview were delayed. Right, let's deal with some aspects of decriminalization inside the Act. In Section 63, these matters which are normally dealt with under this Act through the Magistrates' Court, this bill is proposing that issues which arise of this nature will now be dealt with by the court itself. The bill proposes the removal of the certification of unions for industrial relations offenses, but the fines that have been proposed may have the same effect. For instance, while employers can be fined $200,000 trade unions will be charged $100,000. And I think that trade unions will be hard-pressed to pay fines of this magnitude. Now to keep that in mind, because something else is going to happen later on which would be very interesting. Decriminalization and Section 67, industrial action and essential services. While there is no more prison time for employers, the fine has increased from $40,000 to $100,000. No prison time for workers, but the fines increased from $1,000 to $25,000. So while you have a 250% increase for the fine for the employer, the fine for the worker has gone up by 2,500%. Trade unions calling for industrial action, fine increased from $20,000 to $75,000. In this regard, no decertification, but keep that in mind, keep that in mind. Trade union officers found liable, fine increase from $2,000 to $25,000. So you see how this fine thing is going. New fines under subsection 5 include fines of trade unions of $150,000, which is excessive, and fines for trade union officers of $100,000, plus disqualification from office for 5 years. And liable individuals fined $50,000. So if even an individual, officer or not, the ordinary worker, activist, is found guilty, they're liable to a fine of $50,000. So decriminalization, yes, but the fines are very prohibitive. Section 68 also decriminalized persons liable for giving financial support for industrial action, fine increase from $10,000 to $40,000. Employers and trade unions liable for receiving financial support for industrial action face a fine of $30,000, and an office holder of a trade union liable to a fine of $20,000. That is simply for giving financial support. The bill also amends Section 70A, and Comrade Chair made reference to this in his opening remarks. The recognized majority union is mandated to represent all workers in the bargaining unit, whether they are members or not. Any aggrieved worker, including non-members, can petition the court to have the union's certification revoked. The bill lists grounds for the petition, and the procedure upon receipt of the petition is also outlined. The court has to make a determination within 3 months. So it's 6 months to have certification and so on, but to revoke is 3 months. The Section 70A also mandates the IRA to represent all workers. Right, so that aspect of it is surely going to occupy a lot of time this morning, given the fact that it strikes at the heart of the trade union movement itself, because any employer could ask any of their lackeys to petition the court to have any union decertified. That's a very dangerous possibility. Also, representation costs money. And anybody who understands how a union operates and so on would know that having the burden of representing non-members is going to make unions a very unprofitable organization. As per normal, the DPP will advise on prosecution of persons in contravention of 67 and 69. The bill again prohibits industrial action by public servants, and the bill also proposes to amend Section 78 of the Act. Now, any bill, any act that is passed by Parliament generally is useless without the accompanying regulations. The bill provides for the President of the Republic to make regulations for the proper working of the Act and set fines. Right? The contravention of these regulations, the bill proposes that fines of $50,000, which is an increase from $10,000. Right? Provisions can be made for the regulations concerning employees in domestic nature, which is a piecemeal approach to what the workers' agenda wanted. And matters arising out of these regulations can be heard by the court. Now, those of us who practice in the court will realize that during negotiations, there is a department in the court called the Economic Research Section. The bill proposes the strengthening of this office and a change of title to the Office of Economic, Legal, and Industrial Relations Research. So they're expanding the purview of this section from economic to legal and industrial relations research, and establish several new positions to carry out this new mandate. The director of this new section will also take directions from the President of the Court. Now, fundamentally, those are the amendments to the bill, and comrades will be very aware, based on what has been presented, which are the areas that we need to really discuss. Some concerns have been identified. Based on what has been presented by the workers' agenda, including the severe limitations on the right to strike, this amendment bill has not addressed that at all. The repealing of any provision which allows union to be certified, in our view, we believe that the certification is now a whole lot easier, and while the employer cannot decertify the union, a non-member can have a petition to the court have the union decertified, which is a much more volatile and dangerous situation. To facilitate the unfettered right of workers to join a trade union of their choice, while the recognition and certification process is addressed, the process is completed in 3 months, and we feel, even though that is a big improvement from what exists at the moment, clearly we feel, given the fact that they are calling for 3 months to have the union decertified, we feel that the process should be 3 months as recommended by the workers' agenda. Create the security of tenure for judges. This has not been addressed properly. The bill still offers contracts, even though it's for 5 years. The all-encompassing definition for workers to include public servants and domestic employees. Public servants and domestic employees are still not defined as workers in accordance with the Act. To take legislative measures to prevent employers from frustrating workers from non-unionized environments to be represented by unions of their choice. The bill proposes a 6-month process and mandates that objectors have 28 days to make complaints. To establish an independent body to select judges from the court, this has not been addressed. To make the Ministry of Labor more user-friendly, the bill proposes the removal of the conciliation services and the creation of CAMs. And clearly, that is something that needs to be addressed. I saw in the amendment bill that there's provision for transfer of public officers to this authority, and that is something that we will need to discuss. This whole concept of the Conciliation and Mediation Services Authority. Finally, to remove restrictions from some workers to take industrial action. This critical proposal of the workers' agenda has not been addressed at all. Now, comrades, we have given you a lot of food for thought, and I think we need to address these concerns. What we have done is to put this bill in the context of the workers' agenda, which we as a body came up with 10 years ago, 19 trade unions, and which from all appearances has been ignored by the state. Now, the JTUM over the last 6 months has been interviewing, so to speak, parties in opposition to find out what their views are on the workers' agenda. And the PNM, the ILP, and the MSJ all agree with the key elements of the workers' agenda. And we suspect that process, which was well publicized in the national media, also put pressure on the state to act, but they have acted improperly and not in their interests. So, comrades, we are here today to examine this bill and to come up with our reaction to the bill so that we will go forward ever, backward never. Forward ever, backward never. Thank you.
Okay. It is hoped that comrades were following and taking your short notes as the presentation was made, because we facilitated everyone with a copy of the bill. Without any further delay, I want to open the floor and go straight into comments and questions and discussions and so on. You want to leave enough time for that. So without any further delay, let us go straight to the floor, inviting comrades to state their name, their union, and make their short interventions.
Good morning.
Good morning, comrade.
Yeah, comrades, good morning. I am extremely happy, and all protocols observed this morning. I am extremely happy that on the head table don't have any glass bottles. Comrade Prentice from Amalgamated Workers Union, first Vice President. I am extremely happy this morning, comrades, that at the head table this morning don't have any glass bottles. And also don't have to be worried about any glass bottles in the building, except if anybody would have brought in this morning. What I have to say this morning, some comrades may be angry, but I would be very dishonest if I would sit. I don't know how much longer I could tolerate and accept the fact that's what is going on in the trade union movement today. We have been suffering since 1937. We have gone to various institutions over the years and we have suffered, we continue to suffer. This bill that has been drawn up, it's drawn up in the backdrop where we also have trade unions. And this is what is irritating to me this morning. We also have trade unions, and while we question the government, and we have a right to curse them for the wickedness that they are prepared to do to trade unions, we have trade union leaders who is within the government. We have people even outside the government and in the trade union movement. Now I know this morning that people are going to take back. Well, I'm not afraid about taking back. All get carried. I would say what I have to say this morning because I just feel that I have enough of some of the things that is going on and passing for trade union leaders. And trade union leaders among us is stabbing us in our back and we just sitting back and accepting this. I am saying this morning because I just feel I have had enough, hear enough, see enough. And some level of action, not only to the government, should be taken today in regards to trade unions. Who is heading major trade union organization today? This present administration and former administration would have infiltrated the trade union bodies at some point in time, maybe today it may have been the worst that we have seen in the history of this country. But we have trade unions, trade union leaders that is within our own organization that giving us trouble. Some from our very organization that we are part of. I am a part of NATUC. My trade unions are part of NATUC. And I have a serious problem because I would have sat in a conference of delegates some years ago when I recall a big trade union leader was saying why we should done with JTUM. That is the first. I wasn't there on Saturday and I reported what I would have feared that they tell me second-hand information. But I know trade union leaders here today can't deny what I say here today. When one trade union leader could denounce on Saturday to done with JTUM and don't go to JTUM. But I want to tell you trade union leaders in the organization which my union is a part of, JTUM, over the last 5 years, and I'm saying it with no reservation, has done more for trade union under JTUM than NATUC for the last 15 years has done for trade union in this country. Who vex? But I'm not going to sit back no more and accept this nonsense passing for trade unionism. We must call a spade a spade. This cannot continue come what. We must take a stand for something. I am angry because I feel the time has come for us to denounce this level of deceit and wickedness and evil that is passing for trade unionism. We have it in the government and we have it in our own trade unions. Some of who sit in here, I want to tell some of them wicked PNM people who go forward, I go forward too. So I'm not leaving myself out. And some of you UNC who sit in here this morning and who go forward are saying this morning, come what? I will be the first if Dr. Rowley believe he come in to ram something down trade union belly. This time coming here, he make a mistake. I say to UNC people who don't want to condemn UNC for wrong that they're doing. If God forbid I want to come back in office, I saying this morning, I want to go on every platform and say exactly how I feel because this level of deceit and wickedness must stop. We cannot. We cannot continue sitting back and accepting this and saying this is the norm. This can't be the shitting norm. This can't be the norm. Something must be done. We must stand up and say something. I don't care what he's saying in Africa and China and wherever. This is Trinidad and Tobago. I have had enough. I can't take no more of this. This level is it. Who is NATUC and who is fighter and who is JTUM and who is whatever bullshit. It has done. It has done. This thing has done. We can't continue down this path. We're going on a path of total destruction to the trade union movement. We're sitting, we come out sitting inside the shitting parliament and telling me to accept this bullshit. We are trade union inside the own shitting union saying take this. And then on top of that, you have the goal. You have the goal to tell people, don't go up JTUM. The goal and people sit down in a forum and take that bullshit. Half a NATUC members, half a NATUC affiliates here this morning. Oh God, how much more this we go take? This has to stop, dear comrades. This has to stop. I am prepared to stay quiet after today. This has not done.
Thank you. And for opening the floor in that particular way, given the fact of the level of hypocrisy that would have led to where we are this morning. Let's continue as we invite, as we thank the media for their coverage of the opening, and we invite them to the next meeting at some appointed time for a date to be fixed. Let us thank them for their presence here this morning. And we will continue to support you as indeed, comrades. The workers, the media workers, we know continue to do their work, but it is the business houses, media houses, and the editors who has a vested interest, whose interest is aligned to the government, that does the type of editing that would not see the workers' interest being projected, but instead, some skewed, narrow, and a negative report on the labor movement and so on. One would hope that everything that we did here this morning is properly conveyed and reported. And the last thing we want to say as we thank Comrade for covering this part of the event is to say that this government has been identified by its actions, not by its words alone, but by its actions, as one of the most anti-worker government this country has ever experienced.